substances and identified the weight to you. The weight of the lab report regarding the fentanyl pills stated 15.33 grams, and the DEA lab report regarding the fentanyl powder weighed 16.571 grams. Together, those are above 30 grams, and that's how the state proved beyond a reasonable doubt that it was 28 grams or more. Next, we have count 2. In a similar light, it's trafficking in methamphetamine, 28 grams or more, but less than 200 grams. To prove the crime of trafficking in methamphetamine, the state must prove the following beyond a reasonable doubt: that NIJA Gamble knowingly possessed, sold, purchased, delivered, or brought into Florida a substance, that substance was methamphetamine or a mixture of methamphetamine, and that the methamphetamine or mixture containing methamphetamine weighed more than 28 grams but less than 200 grams. The same evidence and testimony that proved that he had knowledge and control over the substances in that vehicle for the fentanyl is also the same testimony and evidence that shows that he had knowledge and control of the substance of the methamphetamine. They were packaged in a black pouch, sandwiched in between two items that the defendant expressed a knowledge of multiple times throughout this case. And you see the proximity to the substance. You see that he was the sole occupant of the vehicle. You see the identification cards in the wallet, the jail calls that take 5 receipts. We also heard from DEA forensic chemist Carmen Salmon. She testified that the substance was identified as methamphetamine or a mixture containing methamphetamine, and she testified that that weight was approximately 60.6 grams, landing it squarely in between the 28 grams or more, but less than 200 grams. Finally, brings us to count 3, which is the sale or delivery of a controlled substance. To prove the crime of sale or delivery of a controlled substance, the state must prove the following elements beyond a reasonable doubt. NIJA Gamble sold or delivered a certain substance. The substance was cocaine, and that NIJA Gamble had knowledge of the presence of the substance. Here, we are looking at Sergeant Howard's testimony. She is surveilling a known narcotics residence that she testified that she knew a known narcotics residence. She testified to the short-term amount of the stop. It was no more than 2 minutes, I believe, and she testified that she saw an object exchange between the defendant and the 2 individuals right outside the vehicle. Right after the defendant departed that location, he was almost immediately detained. There was no length of time, like an hour in between, where he could have gone somewhere else and then come back. No, it was right when he left that residence. He was picked up. I believe the testimony was within less than a minute. He was apprehended by Investigator Simpkins, and we see that he was separated from the vehicle and arrested. That vehicle was then, as we heard, towed to the Okaloosa County Sheriff's Office. We saw the red tape on the body camera video of all the doors, and then it was searched. And that search was on body camera. We heard the testimony regarding the cocaine being in close proximity to the cash, and we heard testimony from Investigator Landis that is indicative of narcotics trafficking. We also have the sandwich bags that were located in the back seat that match the bags that the cocaine and the other substances were located in, further showing that Mr. Gamble sold or delivered this substance. We heard testimony from forensic chemist Carmen Salmon regarding the identity of that substance, and she identified that substance as cocaine. And we have a lab report stating as much. And then lastly, Mr. Gamble had knowledge of the presence of the substance. This goes back to all of the testimony regarding Investigator Simpkins' body camera watching Mr. Gamble be the sole occupant out of that vehicle. Investigator Mitch Landis' testimony and body camera regarding the search and where he found the particular items, namely the identification documents and the cash. We have the jail calls where the defendant stated words like, "I have money in the car, I have my chime card in the car," and he referred to the car multiple times as "my car." Watch the body camera. He refers to it on the body camera. He refers to it in the jail calls. The defendant exercises control over this car, and at the time of the incident, it was exclusive control. He knew of the presence of those substances that was in the center console. The last thing I want to say in this first bit is I want to talk to you about weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence you should not be relied upon in considering your verdict. You may find some evidence not reliable or less reliable than other pieces of evidence. Listen to the testimony, watch the body cameras, and see how they match up. Weigh the evidence, and then render a verdict of guilty on all of these counts.
Mr. Noakes.
Ladies and gentlemen of the jury, please the court, state. We want to thank you for being attentive and listening to the facts of the case. I guess I'm going to first talk about my client's testimony. He told you that he had not been in that, he was in that car the day that it got stopped, but he had not been in that car. It was the 1st of April, and he paid for the oil change or the service. He said that his girlfriend, basically the mother of his children, drove that car the majority of the time. If you'll remember, when they arrested my client, they did a pat-down search. They didn't find anything on him. No weapons, no drugs, no nothing. There was no testimony to say that he was ever in possession of a black pouch. And that black pouch that I'm referring to would be what ultimately Mitchell Landis said that the drugs were found in. The other thing that's interesting is that even though these things exist, fingerprint evidence, DNA evidence, there was no testing to see if there was any trace of Mr. Gamble on that black pouch. They just didn't do it. The reality is that, my client has concerns that Mr. Landis intentionally covered his body cam during a portion of that time he was at the car collecting everything. Another oddity that makes zero sense to me or my client is that Mr. Landis doesn't do a report as to what he did. I mean, he don't say that the first thing he did was open the door and, he concentrates on the console, he opened the console, and that's the first thing he saw was A, B, C, and it was all stacked together. There's no report, zero report from him. To me, that's just a strange way to do business. You always hear, make sure you basically copy your file. You put the details in writing, you put it in your file, make sure you keep track of everything you do on cases and what have you. The other interesting thing is he decides that, he's got one officer who says in September that everything got sent to the Florida Department of Law Enforcement. And that they had results back from the Florida Department of Law Enforcement. That stuff had already been sent to the DEA at that point. So that's, to me, is just an oddity. How does that happen? The reality is then we find out that Mitchell Landis decided to go and check the exhibit out that was basically the drugs that were found on the 8th of April 2022, and to go through it and repackage it and send it to DEA. There's no video, there's no written report, there was no one there watching him. You have to ask yourself, is that a good way to do business, right? Because even if you're a bank teller, there's other tellers standing there watching you count your drawer, count your till, watching what's going on. The officer in this case literally did it on his own and didn't even make a written report of it. Just seems like an odd way to do business. It seems like, when you're talking about taking people's liberties away, you probably should spend a little extra time and make sure we get, document. Make sure somebody there watching you. My client, he told you that he believes that someone planted the drugs in that car because they weren't in there when he was in there. So the bottom line is is that we've got that side of the case. It's a problem because my clients, he says it wasn't his. He didn't know they were there. The next side of the case, it gets interesting, and this goes to the weight of the evidence. They did have two different reports that say fentanyl. One of the reports says 15.33 grams. Now, when you look at the report and when you heard my questions, you would realize and notice this is exactly what the document that was introduced into evidence says, and it's also exactly what Mr. Bopro, or however you say his name, the gentleman that testified, the DEA chemist that testified, that he tested 9 of the 139 units, which means he tested 9 of the 139 tablets. If you do the math, that means he tested 0.064% of the tablets. And then the sentence on the document goes further and says that the 9 units tested, that he tested 9 units of the 139 units, received indicating to at least a 95% level of confidence that at least 70% of the units, meaning the tablets in that bag, contain that substance. And then he also confirms that basically acetaminophen or whatever, I think it's aspirin, that was found in those tablets. But in reality, what that says is, let's talk about, they're saying 70%, there's a 95% confidence that 70% of the tablets, which would be 97.3% of the tablets, would have been fentanyl. So to me, that's not even close to beyond a reasonable doubt. I mean, they really don't know what the rest of them were. I mean, in reality, that's what that report says. They're saying that basically they only tested 9. So really and truly, if you ask him, hey, you don't know what the balance of, after the 9, you don't know what the balance of those tablets are. He's just saying, he's throwing out that he thinks he can tell you that with a 95% level of confidence that at least 70% of the rest of the tablets is in fact fentanyl. And the importance of that is that there's 2 lab reports, one 15.33 and then the other one is 16.57. When you add those together, you do go above the 28 grams. But if you don't consider both of those numbers, you're under the 28 grams. So it's not as serious of a charge. So that you have to ask yourself, first of all, why are we trying to convict people without testing all of the evidence? To me, that's an interesting question. I mean, I don't know. I mean, if you're going to say I did something or I possess something, then you should test all the evidence. And then bring your chemist in to tell the jury there's beyond a reasonable doubt to me because we tested every one of them. Every one of them showed up positive. But the state elected not to do that in this case. And when I say the state, I'm not particularly talking about Mr. Gomez or Ms. Herman. I'm just saying that the resources or the players that are in the system decide not to test all the tablets. And that to me is just not right. Why shouldn't we, we're not talking about whether or not the man's going to get the $100 gift certificate or the $10,000 jackpot, right? Because then maybe you wouldn't use your resources to make sure that those things get figured out. But it presents a problem to me. I mean, you tested 9 out of 139 and say he's trafficking in fentanyl. You truly don't know that. You know that he trafficked in 9 tablets because you tested them. And if you remember, the chemist couldn't tell me how many grams that was. All he could tell me was that the 16.751 was the gross weight of that package of pills. The state then has this charge of, I guess, it's count 3, did unlawfully and knowingly sell, manufacture, or deliver a controlled substance. I didn't hear any evidence about him knowingly selling cocaine. That's count 3, that he knowingly sold, manufactured, or delivered a controlled substance, i.e. cocaine. There was no testimony that he did that. Closest we got would be Investigator Howard or Sergeant Howard saying, I think I saw a hand-to-hand transaction, but then she said she couldn't tell, she couldn't see anything in anybody's hand, and she couldn't tell who, I think she mentioned the driver was one of the players or characters, but she couldn't tell us who that was. That's what I think she said. There's no testimony that it was even cocaine. She just saw a hand-to-hand transaction, and that's really about the most of it. There was no evidence as to manufacturing or delivering cocaine. Of course, the reality is that, you know, the other 2 counts involve that he did unlawfully and knowingly sell, purchase, manufacture, deliver, or bring into this state. So I don't remember any testimony about him knowingly selling anything. I don't know of any testimony that showed that he was purchasing anything. No testimony related to the manufacture or delivery or bringing into the state. Those words in that part of what they're required to prove, I don't think I heard anything. I heard her say she was at another location that she believed to be a drug house or a residence or another piece of real property, and she saw the 2013 Volkswagen. She couldn't tell us who the driver was. She couldn't tell us for sure that there was anything handed to one another. It just appeared to be a hand-to-hand transaction. And then the next thing I know, he's being held at gunpoint and told to get out of the car, roll the window down, keep his hands up. I mean, you watched it. I didn't see any, you know, a lot of times we see these videos and there's people, there's shadows in the dark making moves, and you can tell they're talking to somebody, or you can tell they are, you know, getting real close to each other, and you can only imagine, well, maybe that's when the deal went down. I don't know. I didn't see any of that. So as far as charging him with trafficking and convicting him of the fentanyl or the methamphetamine or amphetamine, I don't think the state did prove beyond a reasonable doubt, because I don't know that they proved to you that the fentanyl was more than 28 grams. Right back to the pill testimony, just right back to the evidence about the pills. And certainly I don't believe that they showed you any evidence that he should be convicted of the cocaine charge for the reasons I stated. So, I mean, it's my opinion that there is reasonable doubt in this case, and that for that reason you should find my client not guilty. Thank you.
Mr. Gomez.
The defendant wants you to believe that the narcotics were planted. This goes back to weighing the evidence. You have body camera evidence of that search warrant. You have photographs that were taken during that search warrant. You have testimony from Investigator Simpkins regarding the seizure of that vehicle, how it gets to the Okaloosa County Sheriff's Office impound lot, and how he cannot even access that impound lot without a supervisor. The defendant wants to allege that when his hand was over the camera, something was planted. You heard testimony from Investigator Landis about what happened. He did not shy away from what happened. Think about how he explained what occurred with his hands in that body camera and weigh the evidence. Weigh his testimony versus what you see on body camera. And then weigh the testimony of the defendant with what you see on body camera. Weigh it with the testimony that you hear from the law enforcement officers. Weigh the defendant's testimony today against the jail calls that you have access to. You're going to hear the defendant state multiple times, my car, my car. When he's pulled out of the car, he immediately is talking to other individuals on the road saying, can you come get my car? Can you come get my car? Says it multiple times. But he wants you to believe he doesn't have any control over that car, that he hadn't drove it in 6 days, that he left his wallet in there for 6 days and didn't need it. He wants you to believe that when he says it's his car, he doesn't really mean it. If he doesn't really mean that, then what do you actually know that he meant on that stand? If we're listening to a jail call where he's notified every single jail call, this is being recorded, this isn't a private line, and he states, it's my car, we need to get the chime card out of the car, I got cash in the car, and then we find a chime card in the car, and we find the cash in the car. The defendant wants you to believe that he made a sandwich with 2 pieces of bread, but he has no idea the meat that's in the middle of that sandwich. He knows about the chime card. He has a wallet with all of his identification cards. In that wallet, there isn't a single piece of identification information belonging to anybody else in that wallet. You have a black pouch with the narcotics right on top of it, and then you have the cash that the defendant referred to in his jail calls. And his girlfriend did too. Are you not worried about Destiny taking your cash? And then pay attention to this jail call or whatever else is in the car. He's not talking about some cash or other bank account that his baby mama has access to. He's talking about the cash that he has in that vehicle. The defendant wants you to believe that it was planted and that all this wrongdoing occurred because Investigator Landis didn't do a report. He did. There is a report in there. He wore a body camera during the search warrant, and he took photos during the search warrant. He also gave his testimony about what he found during the search warrant. He was very forthcoming with you. I was wearing gym clothes. When I leaned over, my shirt came in front of it, but you can still hear everything that's going on. You hear conversations. They wanted to say that there was nobody was watching. There was a reference to a bank teller and how bank tellers are getting watched as they're counting. Investigator Landis testified that when he checked the exhibits out and he separated them out, he testified that another law enforcement officer watched him seal that and sign it. And the other law enforcement signature is on the exhibits. He didn't just check this out by himself in some sketchy dark room like the defendant wants you to believe. He checked it out of a locked evidence locker that requires logs to get in and out of. He packaged it according to the DEA procedures that he talked about. He signed it and sealed it in the presence of another sworn law enforcement officer and then sent that to the DEA. You heard from the DEA analyst that in order for them to get access to that evidence, they have to type in a password and a supervisor has to type in a password. And then you heard them talk about how they cut a seal and they placed that seal back inside the bag. Back inside of each one of those bags is the original seal. And then you can look at those evidence and you can see multiple stickers and identification writings that was testified to by each one of those DEA analysts. And then they testified that after they got done, They then placed those contents back into the vault, and every single one of them testified that those contents appeared to be in the same or substantially same condition as when they placed that evidence into the vault after their analysis. You then heard Investigator Landis talk about how it stays with the DEA. It got transferred to Pensacola until they went, they got it, they put it in their evidence locker, and now it's here. There's a lot of talk about the fentanyl, the pills, the amount of pills that were tested. This is how I'm going to address that. Nothing that I say or Mr. Nope says is law. You get the law from the court. And I anticipate that the law that you hear from the court is not going to ever tell you that every single pill must have been tested. What it's going to tell you, I anticipate, is that the substance was fentanyl or a mixture containing fentanyl. And then you're going to read another element, I anticipate, that you will hear that that fentanyl or a mixture containing fentanyl weighs more than 28 grams. You also heard the DEA analysts testify that it is common in their analysis to find controlled substances mixed with what I believe they called adulterants. Those are people who have conducted, as they testified, I think somebody testified to over 5,000 analysis. With regard to the sale or delivery, Sergeant Howard did testify that she observed an object being handed. She was very candid that she said that she did not know what that object was. She was very forthcoming with you. She was forthcoming about the fact that she couldn't quite see who was in the car, but that based on her prior interactions, that car was frequently driven by the defendant. You then heard that right after that car left from a short amount of time, less than 2 minutes, I believe, 2 minutes max, he gets almost immediately, I believe it was in less than a minute, gets detained by Investigator Simpkins. And when they detain him, they pull him out of the vehicle. The vehicle is seized, it is secured, and when it's searched, they find the narcotics with a stack of cash right on top of it. And you heard Investigator Landis testify that when you find narcotics and that amount of cash in close proximity, it's indicative of narcotics trafficking. I want you to think back about when we were talking about reasonable doubt. We also talked about forced doubt. The defendant is trying to force a doubt on you. Pay attention to the evidence. Listen to the jail calls. Ask yourself if it's reasonable that the defendant's identification cards and wallet were underneath the narcotics, and the cash that he knows about, that he stated multiple times, were on top of the narcotics. The narcotics were packaged in sandwich bags, and there were sandwich bags located in the back seat of the vehicle. And there is identifying documentation in the glove box of that vehicle indicating that Mr. Gamble expresses control over that vehicle. You also look at one of the cards, for example, on the receipt. If you look closely, last four is the Eglin Federal card that's in his wallet that paid for that Take 5 receipt. And then he wants you to believe that he left his wallet in the car for 5 days and that he paid for everything with Apple Pay. Ask yourself, is that a forced doubt or is that a reasonable doubt? The state believes that with all of the testimony, all of the evidence, the photos, the testimony from the DEA analysts, the testimony from the law enforcement officers, that it has proven this case beyond a reasonable doubt and believes that you should find this defendant guilty on all counts. Thank you for your time today.
Move this. I hope I didn't knock your. All right, ladies and gentlemen. I thank you for your attention during the trial, and I'd ask that you pay close attention to the instructions I'm about to give you. NIJA Gamble, the defendant in this case, has been accused of the crimes of count 1, trafficking in fentanyl 28 grams or more, count 2, trafficking in methamphetamine 28 grams or more but less than 200 grams, count 3, sell or delivery of a controlled substance. Count 1, trafficking in fentanyl 28 grams or more. Certain drugs and chemical substances are by law known as controlled substances. Fentanyl is a controlled substance. To prove the crime of trafficking in fentanyl, the state must prove the following 3 elements beyond and to the exclusion of a reasonable doubt. 1, NIJA Gamble knowingly possessed, sold, purchased, delivered, or brought into Florida a substance. That substance was fentanyl or a mixture containing fentanyl. 3, the fentanyl or mixture containing fentanyl weighed more than 28 grams. Delivery or deliver means the actual, constructive, or attempted transfer from one person to another of a controlled substance, whether or not there is an agency relationship. Mixture means any physical combination of 2 or more substances, including but not limited to a blend, an aggregation, a suspension, an emulsion, a solution, or a dosage unit, whether or not such combination can be separated into its components by physical means, whether mechanical or thermal. To prove Mr. Gamble knowingly possessed a substance, the state must prove beyond a reasonable doubt that he, A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Mr. Gamble had a direct personal power to control the substance or the present ability to direct its control by another. Possession may be sole or joint. That is, 2 or more persons may possess a substance. You may, but are not required, to infer that a person who sells a controlled substance knows of its illicit nature. If you're convinced beyond a reasonable doubt that Mr. Gamble knew of the illicit nature of the controlled substance and of all of the elements of the charge have been proved, you should find him guilty of trafficking in fentanyl. If you have a reasonable doubt on the question of whether Mr. Gamble knew of the illicit nature of the controlled substance, you should find him not guilty of trafficking in fentanyl. If you find the defendant guilty of trafficking in fentanyl, you must further determine by your verdict whether the state has proved beyond a reasonable doubt that A, the fentanyl or mixture containing fentanyl weighed 4 grams or more but less than 14 grams. B, the fentanyl or mixture containing fentanyl weighed 14 grams or more but less than 28 grams. Or C, the fentanyl or mixture containing fentanyl weighed 28 grams or more. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, You will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of trafficking in fentanyl, 28 grams or more, are sale, purchase, deliver, or possession with intent to sell, purchase, or deliver a controlled substance, and possession of a controlled substance. The lesser included offense of sale, purchase, delivery, or possession with intent to sell, purchase, or deliver a controlled substance. Certain drugs and chemical substances are by law known as controlled substances. Fentanyl is a controlled substance. To prove the crime of sale, purchase, delivery, or possession with intent to sell, purchase, manufacture, or deliver a controlled substance, the state must prove the following three elements beyond and to the exclusion of reasonable doubt. 1. Mr. Gamble sold, delivered, purchased, or possessed with the intent to sell or deliver a certain substance. 2. The substance was fentanyl. 3. Mr. Gamble had knowledge of the presence of the substance. Sell means to transfer or deliver something to another person in exchange for money or something of value, or a promise of money or something of value. Deliver or delivery means the actual, constructive, or attempted transfer from one person to another of a controlled substance, whether or not there is an agency or relationship. To prove Mr. Gamble possessed a substance, the state must prove beyond a reasonable doubt that A, he knew of the existence of the substance, and B, he intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Mr. Gamble had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint. That is, two or more persons may possess a substance. You may but are not required to infer that Mr. Gamble was aware of the illicit nature of the controlled substance if you find that he possessed the controlled substance. You may but are not required to infer that a person who sells a controlled substance knows of its illicit nature. If you're convinced beyond a reasonable doubt that Mr. Gamble knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find him guilty of sale, purchase, delivery, or possession with intent to sell, purchase, or deliver a controlled substance. If you have a reasonable doubt on the question of whether Mr. Gamble knew of the illicit nature of the controlled substance, you should find him not guilty of sale, purchase, delivery, or possession with intent to sell, purchase, or deliver a controlled substance. The lesser included offense of possession of a controlled substance. Certain drugs and chemical substances are by law known as controlled substances. Fentanyl is a controlled substance. To prove the crime of possession of a controlled substance, the state must prove the following elements beyond and to the exclusion of reasonable doubt. 1. Mr. Gamble possessed a substance. 2. The substance was fentanyl. To prove Mr. Gamble possessed a substance, the state must prove beyond a reasonable doubt that he A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to the substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Mr. Gamble had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint. That is, two or more persons may possess a substance. If you're convinced beyond a reasonable doubt that Mr. Gamble knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find him guilty of possession of a controlled substance. If you have a reasonable doubt on the question of whether Mr. Gamble knew of the illicit nature of the controlled substance, you should find him not guilty of possession of a controlled substance. As to count 2, trafficking in methamphetamine. Certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of trafficking in methamphetamine, the state must prove the following 3 elements beyond and to the exclusion of reasonable doubt. 1, Mr. Gamble knowingly possessed, sold, purchased, delivered, or brought into Florida a substance. 2, the substance was methamphetamine or a mixture containing methamphetamine. 3, the methamphetamine or mixture containing methamphetamine weighed 28 grams or more, but less than 200 grams. Sell means to transfer or deliver something to another person in exchange for money or something of value, or a promise of money or something of value. Deliver or delivery means the actual, constructive, or attempted transfer from one person to another of a controlled substance, whether or not there is an agency relationship. Mixture means any physical combination of 2 or more substances, including but not limited to a blend, an aggregation, a suspension, an emulsion, a solution, or a dosage unit, whether or not such combination can be separated into its component by physical means, whether mechanical or thermal. To prove Mr. Gamble knowingly possessed a substance, the state must prove beyond a reasonable doubt that he, A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that the defendant had direct personal power to control the substance, or the present ability to direct its control by another. You may but are not required to infer that a person who sells a controlled substance knew of its illicit nature. If you are convinced beyond a reasonable doubt that Mr. Gamble knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find him guilty of trafficking in methamphetamine. If you have a reasonable doubt on the question of whether Mr. Gamble knew of the illicit nature of the controlled substance, you should find him not guilty of trafficking in methamphetamine. If you find the defendant guilty of trafficking in methamphetamine, you must further determine by your verdict whether the state has proved, beyond and to the exclusion of reasonable doubt, that A, the methamphetamine or mixture containing methamphetamine weighed 14 grams or more, but less than 28 grams, or B, the methamphetamine or mixture containing methamphetamine weighed 28 grams or more, but less than 200 grams. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he has been accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will need to decide if the defendant is guilty of a lesser included crime. The lesser included crimes indicated in the definition of trafficking in methamphetamine, 28 grams or more but less than 200 grams, are sale, purchase, delivery, or possession with intent to sell, purchase, or deliver a controlled substance, and possession of a controlled substance. The lesser included offense of sale, delivery, or possession with the intent to sell a controlled substance. Certain drugs and chemical substances are known by law as controlled substances. Methamphetamine is a controlled substance. To prove the crime of sale, purchase, deliver, or possession with the intent to sell, purchase, or deliver a controlled substance, the state must prove the following 3 elements beyond and to the exclusion of reasonable doubt. 1, Mr. Gamble sold, delivered, or possessed with the intent to sell or deliver a certain substance. 2, the substance was methamphetamine. 3, Mr. Gamble had knowledge of the presence of the substance. Sell means to transfer or deliver something to another person in exchange for money or something of value, or a promise of money or something of value. Deliver or delivery means the actual constructive or intended transfer from one person to another of a controlled substance, whether or not there is an agency relationship. To prove Mr. Gamble possessed a substance, the state must prove beyond a reasonable doubt that he A, knew of the existence of the substance, and B, intentionally exercised control over the substance. Control may be exercised over a substance where the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in an absence of additional evidence. Control can be established by proof that Mr. Gamble had direct personal power to control the substance or the present ability to direct its control by another. Possession of substance may be sole or joint, that is, 2 or more persons may possess the substance. You may, but are not required to infer that Mr. Gamble was aware of the illicit nature of the controlled substance if you find that he possessed the controlled substance. You may, but are not required to infer that a person who sells a controlled substance knows of its illicit nature. If you're convinced beyond a reasonable doubt that Mr. Gamble knew of the illicit nature of the controlled substance and all the elements of the charge have been proved, you should find him guilty of sale or delivery of a controlled substance. If you have a reasonable doubt on the question of whether Mr. Gamble knew of the illicit nature of the controlled substance, you should find him not guilty of sale or delivery of a controlled substance. The lesser included offense of possession of a controlled substance. Certain drugs and chemical substances are by law known as controlled substances, and methamphetamine is a controlled substance. To prove the crime of possession of a controlled substance, the state must prove the following elements beyond and to the exclusion of reasonable doubt. 1, Mr. Gamble possessed a substance. 2, the substance was methamphetamine. To prove Mr. Gamble possessed a substance, the state must prove beyond a reasonable doubt that he A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in an absence of additional evidence. Control can be established by proof that Mr. Gamble had direct personal power to control the substance or the present ability to direct its control by another. Possession of the substance may be sole or joint, that is, 2 or more persons may possess the substance. If you're convinced beyond a reasonable doubt that Mr. Gamble knew of the illicit nature of the controlled substance and all the elements of the charge had been proved, you should find him guilty of possession of a controlled substance. Wait for them to move over. If you have a reasonable doubt on the question of whether Mr. Gamble knew of the illicit nature of the controlled substance, you should find him not guilty of the possession of the controlled substance. Now it's count 3.
Excuse me, Your Honor.
Yes.
I'm sorry, Pat. Did this connect your approach?
No-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
almost finished with these part of the instructions, and then we're going to get to some deliberative instructions, and so as soon as I finish this section, we'll give you the brief break, and then we'll come back for the deliberative instructions, if that's okay. All right. So, the lesser included offense of possession of controlled substance, and now we get to count 3. Certain drugs and chemical substances are known as controlled substances. Cocaine is a controlled substance, and to prove the crime of sale or delivery of a controlled substance, the state must prove the following 3 elements beyond and to the exclusion of reasonable doubt. 1, Mr. Gamble sold or delivered a certain substance. 2, the substance was cocaine. 3, Mr. Gamble had knowledge of the presence of the substance. Sell means to transfer or deliver something to another person in exchange for money or something of value, or a promise of money or something of value. Deliver or delivery means the actual, constructive, or attempted transfer from one person to another of a controlled substance, whether or not there's an agency relationship. You may but are not required to infer that Mr. Gamble was aware of the illicit nature of the controlled substance if you find that he possessed the controlled substance. You may but are not required to infer that a person who sells a controlled substance knows of the illicit nature. If you're convinced beyond a reasonable doubt that Mr. Gamble knew of the illicit nature of the controlled substance and all the elements of the charge have been proved, you should find him guilty of sale, purchase, delivery, or possession with intent to sell. You should find him guilty of sale or delivery of a controlled substance. If you have reasonable doubt as to the question of whether Mr. Gamble knew of the illicit nature of the controlled substance, you should find him not guilty of sale or delivery of the controlled substance. Now, there also is a lesser included offense here, and that is in considering the evidence, you should consider the possibility that the evidence may not convince you that the defendant committed the main crime, but there may be evidence that he committed other acts which would constitute a lesser included crime. Therefore, if you decide the main accusation has not been proved beyond a reasonable doubt, you next decide if the defendant is guilty of a lesser included crime, and the lesser included crime in this definition of sale or delivery of controlled substance is possession of a controlled substance. And certain drugs or chemicals are known as controlled substances, and cocaine is a controlled substance. To prove the crime of possession of a controlled substance, the state must prove the following elements beyond a reasonable doubt. 1, Mr. Gamble possessed a substance. 2, the substance was cocaine. To prove Mr. Gamble possessed the substance, the state must prove beyond a reasonable doubt that he A, knew of the existence of the substance, B, intentionally exercised control over that substance. Control may be exercised whether the substance is carried on a person, near a person, or completely separate location. Mere proximity does not establish that the person intentionally exercised control in the absence of additional evidence. Control can be established by proof that Mr. Gamble had direct power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint, that is, 2 or more persons may possess a substance. If you're convinced beyond a reasonable doubt that Mr. Gamble knew of the illicit nature of the controlled substance and all the elements have been charged, you should find him guilty of possession of a controlled substance. If you have a reasonable doubt of the question of whether Mr. Gamble knew of the illicit nature of the controlled substance, you should find him not guilty of possession of the controlled substance. And with that, we'll take a brief break for the jury for comfort.
Yeah, we need to use the restroom, that's all. No, that way you can do the restroom.
And you saw the other oopsie there, right?
Yeah, sure.
Yeah.
The heroin.
Well, and also then in in count 3, where we're directing the jury as to the main charge, if you're convinced beyond a reasonable doubt, then you've included the,
That was what I had approached them.
okay.
But I think you read, if you're convinced beyond a reasonable doubt, NIJA Gamble knew, you read that paragraph, but then the last paragraph on page 4, on 15, I don't know that you read the last
I
paragraph.
did, I changed it.
Okay, good, all right, that's fine.
And I got partially into the sale purchase, and then I changed that at mid-fly. So I think we're good there. But let's get that fixed as well.
Can we take a bit of a break?
Yes, sir.
My client asked for a personal break.
All right, very good. We'll be in recess.
All rise.
You're eating.
Beef and cheese steak.
It's all set.
I'm coming back for 4 seconds.
I'm going to eat.
That's okay. That happens. That's okay. That happens.
You don't mind eating. Ability.
I got a protein bar too.
Sure.
Madam Clerk, where you
How
want
long
protein bar?
will be in?
What was that?
How long break?
He didn't say, so probably 10 minutes.
I'm gonna get me something to drink. I'll be right back.
All right.
What up, JJ?
No rush.
Want a protein bar? Yeah.
Real quick.
Like I have food downstairs,
How
I just
long
can't
is
get
it
to it.
waiting for the officer?
It's going to be up to them.
Once again.
If they keep going, and I'd say if they keep going beyond like 6 o'clock, I'd say, so that's what they want to eat or if they want to go home. Well, if they can get by 6. Probably ain't gonna get by 6, I don't know, we'll have to wait and see.
We're gonna reach that right now. Come back tomorrow and you deliberate, and maybe so long. We'll find out in the next half hour. Earlier, there was some doing, and I looked at him and I was like, what do you want to do back? Oh. Short that time, because they don't want to embarrass guys, stop to see, hey, here you go. There is absolutely no evidence. Surprised that didn't get prove this man is just everything, even the jail phone calls that recorded, and many, when he did, I went a phone call for I mean, Mark doesn't have any choice, he has to take his case and just give him to him. This one he's had, that just said, yeah, here we are. When they go last time, we went to deliberation 45 minutes, and I told him to stay, when we go downstairs at the recess couple hours, I said, this ain't gonna take long. He goes, what do you mean? Then we'll be back to deliberation for 45 minutes, we'll be out of here, which is true. Anyway, we're looking at this stuff. Right, I think it says, say you it, I mean, that person can go, just like I'd be pushed about that. Why don't you do it?
still in there, so.
Right.
When they do that.
Well, they don't have copies at all.
Yeah,
They
I
also
also
have, under normal circumstances, they have to go along with.
Yeah.
I'll be Japanese on the way on Friday.
I don't know, I'm sure.
Yes, sir. Thank you. Appreciate that.
Real cheese out here.
Yeah.
What kinds of woody and
I don't know, maybe I should go.
Jump that up.
I'm still with you. You know, I actually have to go downstairs. I need to get the skin in for the general people. I'll be right.
If they deliberate tonight, and we're out of here by 7, no, I won't be here tomorrow, but if they gotta, he has to go home tonight, come back tomorrow, that's what they may do, then I gotta come back tomorrow. I don't know what they're gonna do. I don't know what I do. I just can't stay home. They scheduled this for 2 days. But it's won't get, they could deliberate tonight. And there's nothing. Yeah, if we come back tomorrow, we won't be here now. Probably start at 8:30, 9 o'clock, we're done before, well, before noon. I don't think this is a waste, it's gonna take long, I just want to be done. Seen many of these, like, they're on their desk. So that's it. So I'll rest when I get on the way home. This is, I don't have a parking lot to be sitting with tonight. See ya. I'm still here. Tell my little boy I love it. Bye.
Me too. What time are you supposed to go?
4. That's it, so.
Water cooler?
What?
12:16. So 6 and 4. Not much.
Because it's just crazy. It's all in on that. So. Okay. Bye.
Time for a little snack, huh?
Oh, right.
Well, I thought it was thinking Pepsi in the shoes. So after I did it, I was.
Yeah.
Oh.
Oh, good.
What I'm wondering is what I'm.
I kind of love that you're using a heating pad. I said I kind of love that you're using a heating pad.
I was told Judge Stone said next month will be 33 years old.
Yeah, I can imagine. I mean, I sleep on one every night, but I would love to have one right about now.
I had that, and then I had sciatica, so then I had ice packs on my legs.
Oh my gosh.
Slide on to just a little.
And then I just went to the chiropractor yesterday.
It is rough. You got it in both
So they can go right
directions.
inside the mags.
Wow.
I use this, his name is Dr. Payne in Desmond. Have you ever heard of him?
Yeah, I have heard, because that's his name.
Judge is on the
He
way back to
is
the courtroom.
a lifesaver.
Really?
He does where he actually adjusts you.
Uh-huh.
And I forgot what the theory is that he uses, but it's not like, you know, how they put you on the table and bounce you. I can get one of those off of Amazon, but he adjusts you and everything. People come from all over town. There's a bunch of people from Funeral.
Really?
Up in the Paxton area.
Yeah, drive down. Well, he must be good.
Yes, he's real good. He's going back.
He's on the way back.
Yeah. Jay's still back there, so. She said she was running a second. Charles, do you know who ended up staying at home?
TJ and Steve. Really? TJ's involved. I think he's involved.
Yep. While I was waiting, I made the mistake of turning on my phone.
All rise.
My fiance passed out here.
For the back session.
Please be seated.
I'm not stable. Here, I'll give you some.
They ready?
Let's see the state printer. Stress on that printer.
Did you double check the verdict form was still good?
Yes, Your Honor, the verdict form is still good. You have a copy, the copy, right?
I do.
Okay.
All rise for the jury. Please be seated. All right. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation of the information through each stage of the trial unless it has been overcome by evidence to the exclusion of and beyond reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or to prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than some of the other evidence. You should consider how the witnesses acted as well as what they said. Some of the things that you should take into consideration are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony the witness gave in court? 7, has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead it depends upon the nature and the quality of the evidence presented. The fact that a witness is employed by law enforcement does not mean that that witness's testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of every other witness. You may rely upon your conclusion about the credibility of any witness. Any juror may believe or disbelieve all or any part of the evidence or testimony of any witness. Statements claimed to have been made by the defendant outside of court have been introduced into evidence. Such statements should always be considered with great caution and be weighed with great care to make sure they were freely and voluntarily made. If you conclude that the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances including but not limited to: 1, whether and when the defendant made the statement he had been threatened to get him to make the statement, and 2, whether anyone had promised him anything to get him to make the statement. If you conclude that the defendants made the out-of-court statement, but it was not freely and voluntarily made, you should disregard it. Now, there are some general rules that apply to your discussion, and you must follow these rules to return a lawful verdict. You must follow the law as it's set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence you have heard from the testimony of witnesses and seen in the form of exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or you're angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision, in this case in any way. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's exclusive job to determine a proper sentence if the defendant is found guilty by the jury. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict must not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. If during this trial I have acted in some way, or if I have said something that makes you believe that I prefer one verdict or another, I pray that you disregard that. I have no desire or preference in the outcome of this case in any way at all. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict for guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. Now, I know it's hard for you to see it all the way over there, but I'm still going to hold it up to kind of illustrate for you what the basic format of the verdict is. It's 2 pages. And we've been through the instructions telling what the primary charges are. There's 3 counts, all right? And count 1, count 2, and count 3 on the second page. We discussed also the lesser included offenses, which I read to you. And that's the organization of the verdict form as well. The 3 counts with the lesser included offenses. And the way the verdict form reads is, it starts out, says, we, the jury, find as follows, as to count 1 of the information, and with an instruction reminding you that you can only find one verdict as to each count. Then A says the defendant is guilty of trafficking in fentanyl, 28 grams or more. And then it says, with another instruction, if the defendant is not guilty of the main charge, then proceed with the lesser included offenses. B, the defendant is guilty of trafficking in fentanyl 14 grams or more, but less than 28 grams. C, the defendant is guilty of trafficking in fentanyl 4 grams or more, but less than 14. D, the defendant is guilty of sale, purchase, delivery, or possession with intent to sell, or deliver fentanyl. E, the defendant is guilty of possession of fentanyl. And then F, the defendant is not guilty. And then it goes to count 2. And once again, starts out, we, the jury, find as follows, as to count 2 of the information, with the reminder to check only one for each count. A, the defendant is guilty of trafficking in methamphetamine, 28 grams or more, but less than 200 grams. And then the instruction, if the defendant is not guilty of the main charge, then proceed to the lesser included offenses. B, defendant is guilty of trafficking in methamphetamine, 14 grams or more, but less than 28 grams. C, the defendant is guilty of sale, purchase, deliver, or possession with the intent to sell or deliver methamphetamine. Then D, the defendant is guilty of possession of methamphetamine. Then E, the defendant is not guilty. Then on to count 3. We, the jury, find as follows on count 3 of the information, with reminder again, only one verdict as to each count. A, the defendant is guilty of sale or delivery of a controlled substance. If the instruction, if the defendant is not guilty of the main charge, Then proceed to the lesser included offenses. B, the defendant is guilty of possession of cocaine. C, the defendant is not guilty. And then there's a signature, a place to date, and a place for the signature of the foreperson to sign. Now, a separate crime is charged in each count of the information. And although they've been tried together, each crime and the evidence applicable to each crime must be considered separately by you, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. There are 3 counts, there's 3 separate crimes, there's 3 separate verdicts, and you must consider them each separate. Counsel, will you please approach?
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So
This is always one of the most uncomfortable times that a trial judge has. Because the reason for that is because of the order in which your names were drawn, one of you was seated as an alternate juror. And it's necessary that we had you serve in case one of the other jurors was unable to complete their service. And as you know, one of the other jurors that we originally selected wasn't able to complete their service. However, fortunately at this time, since the trial is completed and we've finished the jury instructions, the alternate juror will have to be released. And I hope you understand that we really couldn't tell you who you were until this point in time, right? That makes sense. Although I can't let you go into the jury room with the other jurors, you're welcome to remain here in the courtroom if you wish to hear the verdict, or you can leave. And as the alternate juror, you're released from your duty not to discuss the case. However, it's completely up to you whether you wish to discuss the case with anyone or with no one at all. On behalf of the citizens of the state of Florida, the First Judicial Circuit, and Okaloosa County, as well as all of us here at the trial, I thank you for the service at this time. And if you give your notes to the bailiff, he'll take care of them. All right, in a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all of the other jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You're not to communicate with any person outside of the jury about the case. And until you reach a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I've given, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or whatever. The rules do not allow you to have those in the jury room. Kindly leave those devices with the bailiff when you retire to the jury room. If you need to communicate with me, send a note through the bailiff. However, please do not put a note about any votes or any split of your votes. That would not be proper. If you have a question, I will talk to the lawyers before I answer, so it may take some time. You should continue your deliberations while you wait for my answer. I will answer the questions if I can in writing, or will bring you back in the courtroom to answer your questions. During the trial, items of evidence were received. As exhibits, you may examine whatever exhibits you think would help in your deliberations. These exhibits, with the exception of the controlled substances, will be sent to the jury room when you begin to deliberate. Should you wish to see the exhibits containing the controlled substance, please request that in writing, and we'll bring you in the courtroom so that you can view the exhibits. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that apply, you must apply them. For more than 2 centuries, we've lived by the Constitution and the law, and no juror has the right to violate the rules we all share. At this time, the jury may retire to deliberate. All rise for the jury. All right, you may be seated. All right. Now, if you'd come forward, and I'd like you to review all the evidence that we're going to send back and what we're not going to send back. I almost knocked your microphone off.